Hello, everyone, and welcome back to our second lecture for today on types of attacks and legal aspects and cyber laws. We have the honor to have with us Mr. Ashok Ram Kumar. Mr. Kumar has a master's in IPR law and an experience of more than 29 years as a lawyer in handling IPR issues covering the broad spectrum of litigation and enforcement before trial courts, High Court, and the Supreme Court, and is also an expert in valuation and mediation with focus on IPR. Mr. Ashok Ram Kumar is highly proficient in filing IP applications, having filed more than 4,000 trademarks, copyright, and patent applications on behalf of diverse clients and their prosecution before various registries. Additionally, he also has experience in filing and prosecuting international applications in the United States, ARIPO, EU, and Southeast Asia. Apart from litigation, Mr. Ashok Ram Kumar has headed numerous training sessions, lectures, and addresses on specific IPR and IT issues for various sectors, including business houses, National Institute of Fashion Technology, CII, APTTC, JNU, NIT, JNDU, NIMSME, and other government and non-government organizations. He's a member of the Intellectual Property Law Practitioners Association India, International Trademark Association, International Association for the Protection of Intellectual Property, and is also a certified mediator from BIMACC, Bangalore, with focus on IPR mediation. Currently, Mr. Ashok Ram Kumar spearheads the firm Verdict IP in India and Firmat IP in Italy. With no further ado, Mr. Kumar, I give the floor to you to start your presentation. Thank you very much for being here today.
Thank you. Namaskar to everyone and good evening. At the outset, I would thank the organizers for giving me this chance to share my what is called an idea about the various aspects of IT, more in relation to the Information Technology Act and the relevant provisions, concentrating more on the various types of cyber attacks. Now I'll share my screen. I hope it's visible to everyone. Yeah. Is it visible?
Yes, it's visible. Yes.
Yes. Now, the topic that I've been asked to deal with is cyber attacks and their legal aspects. Before I start the presentation, the law that majorly deals with cyber crimes and information technology in India, at least, is the Information Technology Law, which was promulgated in the year 2000. Initially, the law was brought in to legalize online transactions more than deal with offenses. But later in 2000, when the 2008, when the act was amended, lot of new provisions and new provisions relating to offenses were brought in, thereby giving a good teeth to the act. Now let me go through the presentation because there is quite a presentation, so I want to complete it so that you will have 10 minutes time for the questions. Now, cyber attacks occur in cyberspace. What is defined as cyberspace is space in which communications and actions are mediated by network devices that save financial data and sensitive data. Now, all the networks which is accompanied with the saving systems or the media where information is saved, they form the cyberspace. Cyber attacks are committed to obtain this data. Most of the time, let me tell you, any cyber attack is to take a data. Data could be financial, data could be personal, data could be relating to high security issues, data could be relating to military or the defense, data could be relating to what is called as medical records. So many things are there. This results in breach of cybersecurity. Cyberspace is made up of three webs. That is the surface web, which is social media and online websites. Then you have the deep web, which is through IDs and passwords, like legal documents, government files, medical records, and all that. Then you have an alternate to the World Wide Web, which is called as the dark web, which is mostly where illegal acts are performed. Then cyber attacks are launched from one or more computers against one or more computers or network on surface web or deep web, causing financial threat, loss, and breach of national security. Most of the time, it is this three, financial threat or stealing away of huge database or breach of national security. They are committed against society, companies, individuals, industries, and nations as well. Then India is the second most affected country due to cyber attacks, and an average cost of breach had been around rupees 5,000 per attack. But this is only a very rudimentary figure, because this figure relates to cyber attacks that have been reported. Unreported cyber attacks had been many. So this figure of 5,000 Indian rupees is something which is very, very rudimentary and then very superficial in nature. There could be as much as 500% increase in cybersecurity incidents since the lockdown happened and since the lockdown was first announced. Now, the lockdown has given the cyber attackers more time to think, more time to devise, more time to execute, and more time to, in fact, innovate, if I may use the word innovate, new methods of cyber attacks they have been doing. Then I've given a distinction between a cyber crime and a cyber attack. Attack is against one or multiple computers. Any offenses committed by computer as an object of crime, instrument used to commit a crime, or a repository of evidence related to crime is a cyber crime. In a cyber attack, it's at a macro level, that is a large scale level. In cyber crime, it is at a micro level as well as a macro level, because cybercrime can happen on a huge network, it can happen on a single system, it can happen on a thin client server, it can happen on a intranet, or it can happen within a particular area or where the systems are there. Then all cyber attacks are cyber crimes, all cyber crimes are not cyber attacks. Then what is the topic I'll deal here? I divided them into 5 different topics. First one is type of cyber attacks, second is regulation of cyber attacks, then topic 3 is major cyber attacks, then topic 4 is famous cases of cyber attacks, and topic 5 is how do you go way forward in this. Then with regard to topic 1, types of cyber attacks, what are the different types of cyber attacks? Attacks where goal is to disable target computer or knock it offline, right? Now, these are all the different types of cyber attacks. Denial of service, where service offered by a website or server is denied or disrupted to cause loss to the users. Most of the denial of service cyber attacks happens on banking servers or servers where there is, e-commerce goes on a day-to-day basis. So most of the time, these are the servers that are attacked. Then spreading malware virus, it is a program introduced in a computer system to access and transmit sensitive information or infect a system, right? It is access and transmit. So basically in spreading a malware, you first access the system and start transmitting sensitive information, or you try to infect the system for the purpose of either altering the database or corrupting the database, sensitive information database, or seeing that whatever is being put, you get a copy of it, some sort of a bug that is being put and all that. Then website defacement. This is very regular attack on websites which changes the visual appearance. Most of the time, you will find our friendly neighbor, doing website attacks on ours, and sometimes even our cyber warriors had been very active in doing the website attack of other nations and all that. Yes, this is something which is an open secret and goes on. Then cyber terrorism, large scale of disruption of computer networks governed by computer systems. In fact, cyber terrorism also not only relates to disruption of computer network and all that, it also relates to certain messages being sent, certain takeover of sites. You know, certain sites are taken over and then they are completely changed, or their bandwidth or their information is used by the terrorists. Then attacks where goal is to get access to target computer data, unauthorized access. Now I have actually divided them under certain things here. The previous slide deals with attacks where goal is to disable the target computer or knock it offline. The second one is attacks where goal is to get access to the target computer's data. Unauthorized access into other computers. Then phishing. Ask him how many slides. Phishing, fraudulent practice of sending emails pretending to be from reputed companies. This has been in vogue, at least in India. And, you know, I have at least filed at least about maybe few hundreds of cases on phishing that has happened where people have lost money and, you know, where people have, you know, lost even their, you know, what is called as mobile property on this sort of attacks. Then man in the middle, perpetrator positioning himself between the user and the application to steal the data exchange between the actual parties. Now, this is where certain security is relevant, certain security is necessary in the form of, you know, public key infrastructure or digital signatures or encryption. That is very important. Then cyber espionage, unauthorized use of computer resource for obtaining confidential information or rival or information about rival company or nation. Then the second topic is regulation of cyber attacks. How are these cyber attacks regulated? Let me tell you, every cyber attacker is highly conversant, is highly, you know, what is called as literate with regard to the technology, the way how he enters a system, the way how he enters the system without you know, being, you know, without being followed or found. So let me tell you, every cyber attacker is a technologist by himself. So whenever these cyber attacks happen, initially the victim is taken by surprise. Then he has to, what is called as, diagnose how the attack happened. Then subsequently go to the aspect of protecting himself. Now, regulation of cyber attacks, no comprehensive international legal framework currently governing all cyber attacks. In fact, even India does not have one, though we have had, you know, authorities like the Computer Emergency Response Team under Section 70 of the IT Act, which deals basically with an response, with an emergency response situation. But still, I think we are far, we are lagging in some sort of comprehensive international legal framework. Most of the time, it is the international legal framework that is adopted. The international legal framework comes as what is called as a model law or a model legal framework, which is subsequently adopted by various countries. Then a patchwork effort by organizations like the UN and the Shanghai Cooperation Organization has been done, but they had not been able to exercise a control on the growing threat of cyber attacks. They were able to what is called as a resist or stall the cyber attacks, or, you know, sometimes one or two attacks have been successfully stopped, but not really, because technology keeps changing. The cyber attacker is always the inventor. He is the first person to do the work. So the victim is the second person who has to know what the cyber attacker has done and then go ahead and then stop further attacks. Now, no dedicated cyber security law in India except for few provisions of the Information Technology Act and the rules. Then international organizations, the United Nations is there, the World Summit on Information Security in 2000. They had grouped together, and a group of governmental experts in development in the field of information and telecommunication in the context of international security. Let me tell you, because of the borderless aspect of internet, this issue has become a world issue. It has to be now dealt with by all the countries put together, or an organization that takes care of, every country's needs. This report that was given in 2005 was recommendations like information exchange on national legislation, national information and communication technologies, security strategies, technologies, policies, and best practices, and identification of measures to support capacity building in less developed countries. Most of the time, 70% of the attacks, 70 to almost 85% of the attacks generally happen in developing countries and less developed countries. But the majority of the attacks that happen in in uh, advanced nations happen in very high-end areas. So the attackers are very successful if they are able to log into a very advanced nation's repository, and then they are able to draw out information, rather than logging into underdeveloped nations or developing nations, because not much of useful information can be found. So most of the time it is advanced nations that are always there on their target. Then the SCO the Declaration of Head of Member States of Shanghai Cooperation Organization, they stressed on the significance of the issue of ensuring international information security, and one of the key elements of the common system of international security. Now, if you take various provisions of law in the world, now let us take the intellectual property law or the information technology law, that is the best example that can be taken. There was a model law that was placed for all countries to adopt. When the countries adopted it, the framers of the model law said, look, you adopt this model law, but also take into consideration your local municipal laws, and then you frame such a act that that caters to your requirement. See, you can't have a model law as a complete law, because model law only is a representation of what the world thinks as to how the law has to be framed, or representation of how the United Nations thinks as to how the law has to be framed. But insofar as the the regular state law is concerned, like Information Technology Act, you need to bring in even the municipal laws for them to be for you to assist, or for you to effectively implement the law. Then Indian legislation, Indian cyber legislations are based on the objectives and recommendations of treaties and declarations India signed on an international forum. That's what I was telling you. Then cyber attacks include attacks on computers like denial of service, spreading of malware, and conventional crimes like fraud and theft. Then various cyber attacks attract provisions of Information Technology Act 2000 along with the Indian Penal Code and other laws depending on the nature of attack. Now, I would like to tell all the participants here, what were we doing prior to the Information Technology Act, which came in 2000, right? India saw the emergence of internet in as early as in 1992-93, right? We started with what is called as shell accounts, where there was no media, but simple text was coming. It was on what is called as a dial-up facility. Then it went to what is called as internet on cable, then internet on Wi-Fi, then internet on, balanced time, and internet through cable and Wi-Fi and all that. So there was a stage-by-stage development of the technology, stage-by-stage feasibility of information traveling at the speed of light. Then initially it was the HTML, then the dynamic HTML, then various aspects were added to the internet. So today, the internet that you see was not what it was when it started. I think there was a very, very, very huge change with regard to the properties of internet, the way how internet was being spread across the world, the way how media was being shared, the way how database was being put in cloud servers. There's a huge change. So the other laws, depending on the nature of the attack, That means initially when technology IT Act was not there, we had to rely upon the common law, that is the Indian Penal Code, which suggested certain what is called as offenses. In fact, I was handling one case of a identity theft where a person went ahead and then stole the password of another person when IT Act was not there. This happened as early as in 1995. So how I dealt it was actually an experience for me, because I had to bring in the provisions of Indian Penal Code and tell them, look, till a specific act comes, the common law is always in support of the victim. That you should always remember. Then, major provisions of the IT Act was Section 43, penalty and compensation for damage to computer and computer systems. Section 43 was envisaged, uh, when the IT Act came in. If you look at IT Act, I think it was only Section 43 that actually spoke of offenses and the nature of offenses and what is called as categorizing of offenses. If you see from A to J, all these are the offenses that was visualized when the act was brought in. By that time, I think the world was in the internet stage, the internet state of internet was in a very advanced stage. So we were able to, bring out all these offenses. Then 66, computer related offenses. 66 basically converted Section 43 as a criminal offense by using only two words. One is dishonestly and fraudulently, and it prescribed 3 years imprisonment. Now, before the amendment that happened in 2008, 66 was a very, very rudimentary provision. So every lawyer who was trying to sort out a case for his client had to very, very carefully depend on these two words, dishonestly and fraudulently, because both of them were state of mens rea and they were to be proved by evidence or as a prima facie case before the courts. But later, there was a huge amendment to the Information Technology Act. Very important amendments came in Section 66. Balance. Section 66, punishment for identity theft. Maybe if this Section 66 was there at that point of time when I first filed the case for for the theft of the password, maybe it would have been more easy for me to convince the courts. It's not that I didn't get an order, I got an order, but you should look at the way how a special provision gives you an ability to be more clear to the court, because the law itself says what act has to come under that. So most of your work is completed when when the prescription of law is there. Then you had the 66D, which is punishment for cheating by by personation using a computer resource, communication by personation through computer resource with an intent to cheat. If you look at most of the provisions, there has to be an intent, a mens rea, a criminal intent to do something, in the form of damaging or financial loss or theft or getting into an area which you are not supposed to get into. Then 66F, cyber terrorism, balance. Cyber terrorism, intention to threaten unity, integrity, and security of the nation. Then strike terror in the people of the nation by causing damage to person or property. This is the highest provision of punishment in the IT Act, life imprisonment. Now, cyber terrorism is a very specific provision. I also want to discuss one more provision of 66A, which was struck down by the Supreme Court. I respectfully don't agree with that striking down. because 66A, when it was challenged and when the writ petition was filed, there was an interim and an interregnum arrangement that was done for complaints that were being filed by 66A, where the Supreme Court said, look, you take a 66A complaint, but when the complaint is being looked into, an officer of the rank of a DIG or an IGP, that is the Inspector General of Police or the Director General of Police, has to look into it so that a person of that stature will be in a position to understand and then decipher as to whether the complaint can be taken or not. Now, when the Supreme Court completely struck it down, it affected women mostly on the internet. Offenses against women had risen drastically after 66A was removed. Then social media was being completely misused by posting something that was, very offensive, right? When 66A was there, all this was reduced because though 66A was loosely worded, 66A was a deterrence to a person who wanted to write something bad on the internet about some person or, about anything. The most important thing about 66A was it looked at how the person read it and not the intention of the person posting it. So if the intention of the person posting it was very, even very what is called as something which was not amounting to an offense, but the person who read it, if he thought that it was offensive, he could go ahead with it. So removal of 66A was in fact a greater damage done to the act, and I respectfully don't agree with the Supreme Court's judgment on this. Then, the major cyber attacks that happened: attack by overloading a website or network with request making the website unavailable for regular users; DOS attacks like email bombing and net extortion. Now, most of the time, email bombing was a very, very happening thing in the early 2000s, somewhere between 2003 to 2008, somewhere between that time. Even now it happens, but now systems have come in where, this flooding of email address with huge volumes of email can be stopped. And then, there are various systems in place. The next one is a net extortion, use of internal or coercive obtaining money, property illegally using DOS attacks. Now, these are provided under Section 43A, Section 43E, and Section 43F. I would request all the participants to go through the Information Technology Act, read every provision of the law. Though it is not complete, I am of the opinion the Information Technology Act still needs to be improvised, fine-tuned. New chapters have to be brought in, and issues relating to intellectual property has to be dealt. Issues relating to child pornography has to be dealt specifically. But still, the act that is there today still caters to a greater extent of all the cyber offenses. Then spreading malware virus, kinds of computer program or software that destroys, damages, or otherwise injuriously affects the computer resource. Malware, where such as data theft performs malicious activities for data theft, theft of confidential data, disruption of computer systems. Then similar malware attacks are like logic bomb, time bomb, and the Trojans. Now, all these are dealt under the provisions of Section 43C, 43D, 43E, 43F, 43I, and Section 66 of the IT Act. Then website defacement, what is website defacement? It is dealt with under 43A, 43I, 66. Phishing has mostly been a very, very major what is called as offense that was happening. The offense of phishing attracted lot of cyber phishers, because money was something which was very important there. A financial fraud was being done. if you had seen this movie on, the Prime Video, which is called Jamtara, which dealt with most of it, bank frauds, credit card frauds, how phishing was being done. In fact, certain districts in India adopt this as a business, unfortunately. And then there is a turnover for them, and they proudly say this is our turnover. But phishing is a very, very concerning cyber offense that is happening today. Then cyber terrorism, you know what is cyber terrorism? Based on terrorist activities. And most of the time, terrorism not only relates itself to denial of service attacks or confidential data, but also relates itself to what is called as unauthorized intrusion, hacking into sensitive servers, hacking into defense servers, and things like that. Sometimes even cyber terrorism relates to, placing certain malware, placing certain bugs to retrieve information. Various types of cyber terrorism are there. This is dealt with under section 66F. If you read 66F, it is a very, very wide, very small section of about 6 or 7 sentences, but 66F. But, it does not deal completely with 60, what sort of cyber terrorism is. That is where I say the Information Technology Act lacks, because all this has to be defined very, very thoroughly by the Parliament. Then unauthorized access to other computer systems is one. Theft of data, copyright infringement, right? All these are there. Then cyber frauds, credit card and email scams, and salami attacks, which are all dealt with under 43A, 43D, and section 66. Most of the time, 43, with all its, offenses, A to F or whatever it is, deals with these sort of cyber frauds. Now, in a cyber fraud, the intent is to corrupt another individual's personal and financial information, like credit card theft, email scams, salami attacks, which involves unauthorized and insignificant alteration of data, which results in a major financial fraud. You don't need to steal money. It is enough, even if the data is altered in such a way that, that it affects the victim's financial status. Then cyber espionage, this is a very important thing. Use of computer resource for obtaining secret and confidential information, and this is part of section 66F of the IT Act. Then famous case studies of cyber attacks, which happened in India and worldwide. The first cyber attack known in the world happened in 1988, which is Morris worm. Unfortunately, this gentleman developed a form of a program that could creep into every device without an intention to what is called as damage the database or alter the database. That was his intention. But what happened was this program crept into every device and started infecting. It started infecting, and then there was a denial of service and crashing of the system. This person, though it was not done with an intention to damage this thing, but he was booked under the Computer Frauds and Abuses Act 1986. Then there was a fine levied on him. I think it was about $10,000 or something. Then of course this gentleman is still working, but it is a past for him now. So this was the first major attack. Then second was the Yahoo breaches that happened in 3 different times. One was in 2013, 2014, 2016. Now, 1 billion users in 2013 were breached due to unauthorized entry of a third party. In 2014, it increased to, it was at 500 million. Details involving personal information was obtained by hackers. Okay. Then in 2016, 200 million Yahoo accounts were presented for sale on the darknet. Now, if you know about darknet, only illegal information happens. There are, our intelligence agencies had been successful in 66 years in parking themselves in the darknet and getting to know what is the transaction that is happening. It's a very, very specialized way of getting into it and coming out without being noticed. Then Cosmos Bank cyber attack happened in 2018. where 94 crore rupees was siphoned off. 1,400 transactions were reported. Over 250 cards were used across 28 countries, and the said money was deposited in a Hong Kong-based bank. 94 crore rupees siphoned off. Then, Aadhaar software hack. This happened in 2018. More than 1.1 billion Indian Aadhaar card holders' information was compromised. Now, information security is a very, very important aspect. Now, we are going to bring in the data privacy bill, where there is an insistence for the data localization and how the data fiduciary gives his information. What is it he can give? He has his own. He's given the he can decide on what to give and what not to give. But it is still at the bill stage. I hope this becomes an act, because it's a wonderful bill that will be brought in, though many of the IT companies are against it. But what is more important is the data localization, because that helps the police or the cyber crimes units to solve the cases. Then Pegasus attack, which happened on WhatsApp in 2019, allegations that the Indian government breached the WhatsApp account intentionally to find out. I mean, these are all matters to be proved. They have not yet been proved, but Pegasus attack happened in 2019. Then, what is a way forward? How are we discussed so much about cyber crimes and this sort of cyber attack. How do you stop it, and what is technologically, how are you going to stop it? Legally, how are you going to stop it? That is most important. Presently, increased activity on cyberspace is resulting in rise of cyber attacks. The stress is on strengthening of cyber infrastructure and formulation of strict and effective laws. Now, I'm so sorry. IT Act must define the existing cyber attacks rather than defining the various ingredients of the crime. So specifically, you should say what is a cyber attack. Suppose some salami attack. What is it? What is the prescription of punishment? Then defacing a website. How is defacing of a website done? What is the prescription of punishment? All these are relevant, necessary, and the Information Technology Act has to dwell deep into all these issues, make the act much, much, much more what is called as comprehensive. New legislation to mandate all databases and confidential personal information. They have to be protected by a certified firewall, and a technology akin to PKI digital signatures has to be brought in. Access to investigative agencies of all relevant and necessary data for investigation should be made mandatory. It is not, it has to be made mandatory. Data localization would help this. So most of the times when I deal with cyber crimes cases, we find a lot of difficulty in getting the relevant information pertaining to when was the message sent, who was it sent to, from which number it was sent, what is the time it was sent to, all this. It has to come from outside the country. Then overlapping of punishments of similar attacks must be avoided. There are some overlapping that is happening under the IT Act. Then recognition of new technology developments like artificial intelligence, Internet of Things, Bitcoins to avoid escape of perpetrators and provide safe cyberspace for users. Because artificial intelligence is not only for the development of the country, for development of business, for development of agriculture, for development of industry. It can also be misused by cyber attackers. Then establishing a cyber intelligence unit to do a continuous monitoring on potential threats. Though in India we have something called as a CERT, the Computer Emergency Response Team. I am of the opinion that you need to have a cyber intelligence unit on the lines of the research and analysis wing or any other intelligence unit which does a continuous monitoring. There has to be a continuous eavesdropping. There has to be a continuous monitoring of messages that are going out and coming into India. All this is very important, though it might look like you are interfering, but at the end of it, nation's security is very important. However, one has to take these attacks as a blessing in disguise, because they are providing scope for strengthening the existing cyber infrastructure, both legally and technology. It does not mean that you suffer a cyber attack for you to learn. But once you have suffered one cyber attack, you should be in a position to understand what is the future holding for you. Right? Now, this completes my PowerPoint presentation. If there are any questions that I need to answer, please do ask me.
Thank you so much, sir, for your presentation. Indeed, there are some questions, so we can begin right away. How is impersonation different from identity theft?
Impersonation, see, identity theft is generally with regard to electronic signature, right? 66C, if you read, it deals with electronic signature. So identity theft is generally with using the electronic signature of someone else, because you create an identity on the internet by using the signature saying, I'm so and so, that is why I'm using my digital signature. With regard to what was the question, the other one? No.
Yes, it's impersonation versus identity theft. Which are the differences?
Yes, with regard to impersonation, impersonation generally deals with where you represent yourself in a document as someone else, right? You impersonate. Now, if you have developed, let us take your scanned document and then impersonated yourself in the document, it amounts to, what is called as impersonation. Identity theft is a serious offense. I have dealt with cases on identity theft, and unfortunately, highly learned people have been convicted in that. So, identity theft generally relates to what is called as digital signatures.
Thank you. So the next question. The IT Act and IPC mostly deal with law enforcement and penalty. How does the idea plan to deal with preventive and psychological aspects of cyber attacks, such as psychological profiling of data, election, and fake news?
Okay, that's a very good question. But let me tell you, as I told you, IT Act is still not complete in a manner that it can deal with all these things. Now, in a way, the Privacy Data Bill will support IT Act, but even that needs to be further enhanced. I have gone through the bill and I feel it still needs a further enhancement, though some part of the industry does not agree. They say it is too very draconian in nature, and then you cannot have such law. But I feel that the combination, let me tell you one thing, it is a combination of acts that will work. You cannot have a single act dealing with everything. So it will be Information Technology Act in combination with the Indian Penal Code, and if the the data privacy bill comes in with the thing read with the rules and regulations under the Information Technology Act, this is the combination that has to be adopted. So with regard to the last part of the question, yes, we need to develop, we need to improve the act, we need to amend the act so that it can deal with all those issues that you have mentioned.
Thank you. The next question has to do with a particular article, 66F, and because the person doesn't clarify the content, if you could repeat this. The question is, does Article 66F read together with UAPA, which has a precedence, Article 66F or UAPA?
Yeah, see, 66 is punishment for cyber terrorism. Now, according to me, this act mainly deals with the intent, right? But and it says it prevents an attack on friendly nations. Now, why is this being brought in? To maintain relationship with friendly nations and to assure the friendly nation that India is capable of dealing with such offenders, and then such offenders can be punished. Then what defines a friendly nation and there is a danger to people is a question of fact, right? What defines a friendly nation depends on the facts, what sort of a relationship you have, if you have any treaties between yourself, between yourself and the other country, yes, that can define. And certain even covert operations which you have said, like, let me tell you one thing: covert operations are done by every country. Now, sometimes it is also done on the friendly nation without the idea or the knowledge of the friendly nation. But then, all this, whatever you said, port scanning and critical infra can be construed to be illegal. It all depends on the facts and circumstances of the case. Tomorrow, one country can be a friendly nation. Today it could be a friendly nation. Tomorrow it could be an enemy nation. So it all depends on the facts and the circumstances of the case. But 66F is a promise by this country to friendly nations saying that if there is an attack on friendly this thing, yes, we will take action.
And if I can extend on that, what is the definition of a friendly nation? And is there a danger to people who might be contracted by the government in a covert technology vendor? Should they invoke 66F?
See, is how do you define a friendly nation? I already told you. It depends on what sort of a relationship you have. Now, what is a friendly nation is the definition has to be looked elsewhere. Your IT Act does not give. But yes, if is there a danger to people who might be contracted by the government in a covert operation? The moment you say covert, it is completely secret, unless and until you are caught red-handed doing that operation. Now, as I told you, every country has its own security policy. Security of the nation is very important. But then, if a covert operation has to be done on the net, there are people who are doing it. Governments employ, top, IT consultants and top IT people to do it. But how it relates to what is called as a friendly nation is something that it can't be explained, because generally these sort of operations are on a level to get information. See, like, let us take, if you are going to do a small online covert operation in Nepal, to know how much of their political, how the political party is bent upon towards China. Well, yes, it can be done, because you need that information to be more what is called as vigilant. So it all depends on the facts and circumstances of each case.
Thank you. And in the case of covert operations and cyber intelligence by the government, uh, is there a danger of personal data and data privacy, and how can we mitigate this danger?
There are two things. You are doing a covert operation in another country, or someone is trying to do a covert operation in your country. Yes, when you are doing it in another country, data could be one of the aspects. Information, it could be anything. Information about the political crisis, information about the financial status, information about how, what is the orientation of the people or the religious orientation, all this. It is all data. So when you are doing a covert operation in another country, yes, you are taking data from that country. You are depending on the data that has been generated in that country. That is one. Second, if someone else is doing a covert operation in your country, it is for you to see that your data is secure, your data is protected, there is a firewall, and that your data is not compromised. So in any operation, covert or overt, in any of the operation, most of the time it is the data that assists the person who needs such information.
Thank you. The next question, are there any mechanisms to detect the attacks before they occur? And are there any related data sets for this purpose, also for research purposes?
Unfortunately, Many of us have learned lessons only after an attack. Now, as I told you, you could be prepared for an attack on a particular aspect, but the attacker has designed it in such a way that he has done the attack through another source. Now, how you are going to protect yourself, what sort of a technological barrier or a firewall you are going to have, depends on how you envisage or how you look at a future attack that is happening. Now, today the attack could be on a internet or on a website. Tomorrow it could be on an IoT. If someone is able to hack onto your IoT and manage the system, how are you going to do it? How are you going to stop such a intrusion into the IoT systems? So these sort of things are, see, let me tell you one thing. The thief is always smarter. The hacker is always smarter because he has got a particular method of doing it and he devises the apparatus or the program for that purpose. Now, after the hacking happens, you realize an hacking has happened. Then you go to the first thing you do is where was the breach that happened. Second thing you do is how do I block the breach, right? Then that is the time you start developing software. That is the time you start looking at certain things. Now, let us take on the medical terms, if someone is developing a vaccine for the COVID, so they may not be developing a vaccine for the COVID, they may be developing a vaccine to prevent a respiratory system attack, which will not only take care of the COVID, but any future thing that is developed for the purpose of attacking a respiratory system. So it has to be a generic idea of what you are developing and not a specific idea.
Thank you. The next question, what is the persecution rate for cyber frauds in India in comparison to other countries?
Okay, you mean prosecution, because persecution has got a different meaning altogether. So
probably it's prosecution.
Prosecution rate of cyber frauds. Unfortunately, the prosecution rate of cyber frauds is not very encouraging. Let me tell you that. There are two important reasons for it. The first reason is the lack of technical knowledge amongst the investigating agencies. We have cyber crimes police stations, we have cyber forensics units, but they are overburdened. Let me give you one simple example with regard to OLX frauds. One police station in Hyderabad receives almost 110 complaints every day. 110 complaints. Now, each complaint has to be dealt on its merits. So, how did the fraud happen? How was the money sent? Who was the person who took the money? What was the bank account given? So, you see, they are overburdened with what is called as so many cyber complaints. That is the first thing, overburden. Second, technologically, you are not supplementing the existing team of officers or team of forensic people by bringing in new people. In fact, my suggestion is to open this cyber investigation to private agencies like companies, who can help the police. More the number of people dealing with it, lesser and lesser the pendency of the information technology cases or cyber crimes cases happens.
Thank you. The next question, can investigating agencies be liable for leaking personal data within the current ambit of IT Act or under the IPC?
I don't think they can be held personally responsible, because sometimes personal data is necessary for you to investigate a particular case, right? Now, let us take the SMSs or the WhatsApp messages sent in the Bollywood case to so many people, right? Now, you can't get into my WhatsApp account and look at what happened, because if I don't get into your WhatsApp account, I may not be able to successfully or thoroughly investigate the case. So I don't think investigating agencies can be held responsible for leaking a personal. Now, the question is, whether the investigating agency leaked or was it told by the victim himself. Now, let us take an accused has been cross-examined or has been interrogated in a police station, and the investigating agency found out certain information. If this accused comes out and makes a statement in the TV saying, look, I have given the investigating agency the information pertaining to what happened on my WhatsApp messages, can that be called as a leak? But to answer your question straight away, there is no provision under the Act to make them liable, even if a leak has happened.
Thank you. And maybe is there a limit to how much information can investigative authorities collect, and how can they use this information? I'm guessing personal data.
Okay, it all depends on the facts of each case again. What is the information that needs to be collected and what is the information that needs to be used? Now, generally in an investigation, any investigating agency would like to collect the maximum information, right? Then what they will do, they will deduce the information, arrive at the infringing part of the information that will make the accused liable, right? Now, when this happens, you will have to go through the various information that you have got. It could be WhatsApp messages, it could be emails, it could be so many other things, even hard copies, their own systems being looked into, their own systems being what is called as digitally footprinted to know what has happened on the system. Yes, any investigating agency will look at a huge database so that they will have an option or they will be in a position to zero in onto the event that makes the accused vulnerable.
Thank you. The next question, are there any differences of regarding PII perception in the GDPR and in the California Consumer Privacy Act?
See, GDPR is by the Western countries. Now, there are certain differences. That's what I told you. Every nation has to include its municipal laws in a law that is adopted from another country. They can't just take it as it is and then put it there. It can't be done like that. Now, there are differences. And what do the differences mean? The differences mean the method of working of such an act in this country and the method of working that act in that country, right? Most of the time it is a privacy issue. What is an offense in India may not be an offense in US, and what is an offense in US may not be an offense in India. So your act has to be modulated, it has to be adopted, it has to be acclimatized in such a way that you take the spirit of the international law, but at the same time, you insert ingredients of working of the local law in the said act.